Good day, Crime Talk aficionados. I hope you had a wonderful Christmas. First, does Luigi Mangione have a chance to walk because of jury nullification? Preparation has begun for the Bryan Kohberger trial in July. Jennifer Crumbley's attorney won her release from custody. A DA is forced to retire due to some inappropriate comments. A conviction in Ohio is reversed for a woman who killed her mother. Some holiday food violence for you. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications so that you receive notice of when we go live or put up new content. And yes, you can check us out on any of your favorite podcasting apps. So it is Friday, December 27th. Hope you all had a wonderful Christmas. I think it's now day 2 of Hanukkah. And Happy New Year as well. Now, before we get into the show, let's, talk about CrimeTalkSearch.com. The year's coming to the end. You know you met some people. You know next year is going to be different. You're going to get the year started off great. So what are you going to do? Those people that you just don't have the warm, fuzzy feeling for, go check them out. How do you check them out? You go to CrimeTalkSearch.com, sign up for that background subscription service so you can get a complete, comprehensive background search completed literally while you wait online. It'll be emailed to you. You can get updates of any changes on that information while you have that subscription. And remember, you can cancel that subscription anytime. So whether you want to do one search or whether you want to do 1,000 searches, you can do it. Go to CrimeTalkSearch.com. You're going to be happy you did. All right, let's go ahead and get started with the docket today. Like I said, it is Friday, December 27th, 2024. First, Luigi Mangione. I mean, the evidence is starting to look pretty overwhelming as it relates to his guilt. Now, obviously, we have to give him the presumption of innocence, which he is absolutely entitled to. And guess what? There is a possibility, if you get the right jury, he could be found not guilty. Now, that's going to take a lot of work, but let's get into it. So the prosecutors, they're facing an uphill battle trying to convict Luigi Mangione in the murder of United Healthcare CEO Bryan Thompson. And when I say they're facing a battle, their first 2 counts are charging terrorism, completely overcharged, and I think that's going to be pretty hard-pressed to prove. Anyway, so Mangione is accused of killing Thompson, and firing and killing him outside of a Manhattan hotel where he was going to speak to investors, and he shot him in the back. Kind of cold if you think about it. Now, this all took place back on December 4th. Anyway, Luigi Mangione gets arrested. Alvin Bragg calls the attack frightening, well-planned, targeted murder that was intended to cause shock and attention and intimidation. Hence the reason they got this terrorism charge. Now, we went through the charges last week in great detail on our live. I guess it was actually 2 weeks ago. But terrorism, no, just go with count 3, second-degree murder, and you'll be good. Then you still got the feds going on. Yeah. Anyway, it is what it is. Overcharged. Anyway, Alvin Bragg said that, why he thought this could be terrorism-like is that this was done in a busy part of the city. There were commuters, business people, and they were just starting out their day. And so under New York law, such a charge can be brought when an alleged crime is intended to intimidate or coerce a civilian population, influence the policies of a unit of government by intimidation or coercion, and affect the conduct of a unit of government by murder, assassination, or kidnapping. Okay. How are they going to prove that? Anyway, a little unusual for New York prosecutors to apply the terrorism charge to a case where they believe the broader target was a specific industry rather than the government or a public at large. Just think about that, ladies and gentlemen. Anyway, so Luigi Mangione's already pled not guilty to the terrorism charge, and the prosecutors will likely have a difficult time trying to convince a jury to convict Mangione, because he's got some popularity and support going on. It's crazy. So following Thompson's death, social media was flooded with not only United Healthcare members, but other people providing their experiences in regards to claims being denied. So although murder is always wrong, Mangione basically has all these people saying he's a hero. And he's got some good things going for him, right? He's a good-looking guy. He's Ivy League computer scientist, prominent, wealthy family, and he's angry at the U.S. healthcare system. People are going to be like, hey, this guy's likable, right? Think of all the other people that killed their wives and their children, like the Chris Watts of the world, and all these guys get fan clubs and people saying they want to, spend the rest of their life with them. Well, at least this guy has a little something going for him, and if he gets the right plea deal, he may actually get out someday. Anyway, we digress. So, like I said, the evidence is not looking good. Mangione allegedly used bullets that he had inscribed the words deny, defend, and depose. Those were found there. And then when he was arrested in Pennsylvania, he had a manifesto allegedly outlining his grievances against United Healthcare. And then he puts in there, save a lengthy investigation, I'll state that I plainly was working alone. This was, a little trivial, so to speak, but some elementary social engineering, basic CAD, and a lot of patience, he allegedly wrote in the manifesto. He went on to say that he had respect for federal investigators and apologized for causing any traumas, but seemed to defend his alleged actions. And he said, finally, frankly, these parasites had it coming in the manifesto as well. It claimed the United States had the most expensive healthcare system in the world, but blasted the system for making America only the 42nd in life expectancy. So people grabbed onto this and they said, yeah, you're right. Insurance companies are bad. And don't get me wrong, insurance companies, they suck. They really, really do. But you can't go around killing your CEO of insurance companies because you don't like insurance policy. I frankly would get rid of most insurance and I watched the costs go way down, but that's just me. Anyway, police also said they found a gun on Mangione with shell casings recovered at the scene with his fingerprints, as well as a water bottle and energy bar wrapper found nearby. And let's not forget his to-do list that he had in his possession as well. And there's also talk about whether he wanted to, use a bomb, but that would have targeted innocent people. So he went with the more precise, a ghost gun. Anyway, he also reportedly bragged that it couldn't get any better than to kill a CEO at his own bean counting conference, where they were disclosing their financial gains that the company had made throughout the year. So despite these allegations, like I said, Mangione has quite a fan base. He's been flooded with support, including donors fundraising for his legal defense. Demonstrators were outside of his arraignment in New York on Monday, holding signs offering support for the accused murderer. And many of the Mangione fans refer to him as a vigilante-style hero. He also took drastic action to send a message to the healthcare industry, which people like. Now, prosecutors, like I said, charged Mangione with murder as an act of terrorism in an effort to send this message to anyone to think that they can try to change policy, whether in the government or corporate policy, by killing people. So that's why they thought they had to do that. Anyway, like I said, New York law describes defendants' intent to terrorize the civilian population or influence the government. Now, it's hard to conclude that the legislature intended the phrase civilian population to encompass a person working for health insurers who make coverage decisions. But it's a unique, novel legal theory, and we've been getting a lot of those lately anyway. So we'll see how that works out. But what is Luigi Mangione's best argument? It's an argument that his attorneys can't actually make, and that is one for jury nullification. Jury nullification is when a jury says, not guilty, when the evidence is somewhat overwhelming that somebody did it. And the jury never has to explain exactly why they made the decision to find somebody not guilty. But it's pretty tough to do that. I remember years ago trying cases when people were charged with possession of marijuana. It was a felony. And we would go to court and we would act like this is not a referendum on whether marijuana should be legal or illegal, ladies and gentlemen. It's a question whether the act took place. Go to trial, present evidence. Jury says, clearly the client possessed marijuana, but the jury would find the defendant not guilty because that was their way of saying, we don't like this particular law. We think it's an injustice that this person was, in fact, being prosecuted in the first place. It may be the law, but we don't like it. That's what you have to do. But you can't say, hey, let me tell you about jury nullification. You're not allowed to discuss that in front of a jury. You have to kind of imply. You have to try to hope in voir dire, which I've always said is the most important important part of any jury trial is to get the right people on that jury that are usually bold enough to stand up for what they believe in and willing to say not guilty. But like I said, that's going to be tough. Why? Because a lot of those people, if they voice those concerns, like I said, for the example of marijuana, where they said, oh, it's stupid law, those people are going to get booted by the prosecution. So they have to kind of lie in wait, so to speak, because if they say too much, they're going to get booted, right? If you're overly biased in favor of one side or the other, then yes. So obviously people who are somewhat biased in one way in favor of the prosecution or the defense, or if they posted things on their social media, guess what? They're going to be found out and they're never going to make it to the jury. The other thing is the whole process is sort of forcing people to get serious, right? It's really hard to sit through weeks worth of evidence that this person shot this victim in the back and then just said, heck with it. I kind of like this guy. I saw some social media memes that I thought was interesting. So that's probably not going to happen because most of the time, jurors have to take an oath to follow the instructions that the law is provided to them by the judge and apply the facts of that. And if they disagree with the law, it doesn't really matter. They take an oath to follow it, whether they disagree with it, understand it, or anything along those lines. So most of the jury is going to do that. So jury nullification, like I said, is tough. And so also you have to understand it's a big filter to get these people that aren't willing to follow the law and the instructions. It's going to take real tough. Now, guess what? You need 12 people, obviously, for a not guilty, right? The decision must be unanimous, either guilty by all 12 jurors or not guilty with all 12 jurors. But you can obviously, if you only have one person that says, nope, that is enough. I have doubt that he is the shooter. That's all it takes. Then you hang the jury. And then you got to go do it again. The prosecution and the defense have to go through it again. So although a lot of people are really hopeful that Luigi Mangione, if he goes to trial, he'll be found not guilty through jury nullification, or maybe they just raise reasonable doubt, it doesn't matter. But it is going to be very, very tough because the jury selection process filters out all those people that shouldn't be there because of their biases one way or the other. Now, Luigi Mangione is due back in court on February 21st, and like I said, we'll give him the presumption of innocence. Next on the docket, the Bryan Kohberger case. They are getting ready for that trial that's going to start at the end of July. Now, for those who do not know, Bryan Kohberger is accused of murdering 4 University of Idaho students back on November 13th of 2022, specifically Madison Mogan, Ethan Chapin, Kaylee Gonsalves, and Zaina Kernodle. Now, we are obviously still months away from the start of the trial, but the courthouse is apparently gearing up for everybody to show up and watch the trial. It's still unclear whether the trial is going to be televised or not, but the deputy administrative judge, a guy by the name of James Cawthorn, who's apparently been a judge for about 20 years, and says that he's seen some really big trials. Obviously, the most recent ones were the Lori Vallow and the Chad Daybell there in the Boise, Idaho. But they are gearing up, and it says it's like a big choreography, like a sports team coming together. They're talking things through, game planning things, trying to execute to make sure everyone has all the resources they need and that the trial goes quite smoothly. Obviously, one of the things they have to worry about is security. Now, obviously, he's not going to be able to say a whole lot, but he wants to make sure that the courthouse is safe and secure for all the participants involved in the trial. Now, the jury selection process is also going to be a little different, especially for a case that's generated national attention. So obviously, you got to have the solemnity of a court proceedings. Obviously, there's a lot of emotions going on, and there's a lot of serious issues as well. Now, the crime itself that's alleged is pretty serious, and then to make a jury be called upon to make certain decisions that are quite significant. So you have to make sure that you have a significant jury panel in a case like this. Now, the number of potential jurors summoned will be probably in the close to 2,000 for this particular case. Just to give you some context, for the Lori Vallow trial, there were 1,800 potential jurors that were contacted, and some 25 potential jurors were summoned for the Chad Daybell trial. Obviously, the goal is to find people that have no knowledge or little knowledge of a case and then are willing to set that aside, whatever they do know about it, so that they can give the defendant and the prosecution a fair trial. So they're gearing up for it, but like I said, it's unclear whether cameras are going to be in the courtroom. No decision's been made as of yet. But either way, we will bring you the news. We will bring you the trial, one way or the other. Whether it's nightly summaries like we had to do with Lori Vallow, we put we put up the recordings up every night. Chad DeBell was televised, so that was easy to do. But this one's going to be interesting, and we've talked about the Bryan Kohberger case many, many times. Is there an alternate suspect? Should they suppress all of the DNA evidence because of violations of constitutional rights to privacy? Pretty tough argument to make with the genealogical DNA that the prosecution is relying upon. It's going to be an interesting trial one way or the other, that's for sure. So like I said, the trial is scheduled to start August 11th. Jury selection begins July 30th. Either way, whenever it starts, we'll be there for you. Guess who would like to go home? Jennifer Crumbley. And I get it. Now, obviously, if you've been following the program for a while, you know Jennifer Crumbley. She was the mother of the convicted Oxford shooter. And she is requesting that a judge release her from prison, maintaining that it would be grossly unfair and unjust to keep her locked up during her ongoing appellate process. Now, the request to be released came after Miss Crumbley was convicted on 4 counts of involuntary manslaughter for the shooting her son, Ethan, carried out back on November 30th of 2021. Now, we've talked about this totally unique legal theory that's been tried. Totally disagree with it. I know. All the haters just tell me I'm wrong. But I think the appellate courts are going to agree with me. Anyway, the victims at the shooting were Tate Myrie, Justin Shillings, Hannah St. Julian, and Madison Baldwin. And there were 7 others that were injured as well. Now, her husband, James Crumbley, was later convicted on the same charges as she was. But Crumbley's attorney, a guy by the name of Michael Desi, filed a motion in the Oakland County Circuit Court on Thursday, arguing that Crumbley is not a flight risk and poses no danger to the public. He says, quote, "This case has been bungled, starting with the prosecution's overreaching charge of involuntary manslaughter of a parent for the intentional criminal acts of her son, who was charged and treated as an adult in the eyes of the law," the attorney wrote in the court filings, which I totally agree. I totally agree. You're charging her for being a bad parent when the child is being charged as an adult. Think about that, ladies and gentlemen. Like I said, and if being a bad parent is going to be criminal, everybody better lawyer up, because I think as parents, we've all made some poor decisions. And like I said, if she was saying, "Come on, Ethan, today's the big day. We're going to go in and shoot up the school," that would be wrong. That would be a complicitor. That would be a conspirator. But if you have no idea and you think you have a troubled kid and you're going to deal with it when we get home tonight, I don't see how that is involuntary manslaughter, ladies and gentlemen. I just don't see it. But hey, what do I know? I will just leave it at that. What do I know? I've never tried a single case in my life, have I? Yes, I have. But it's always funny how everybody who's never tried a single case in their life knows how exactly everything works in a courtroom. Anyway, the attorney, Mr. Desi, argued that the Crumbleys should not have been locked up until her case reaches the Michigan Supreme Court, stating once again in the brief, "It would be grossly unfair and unjust to keep Mrs. Crumbley locked up for years while the matter proceeds slowly, likely for years before the appellate courts," noting that she'd already been locked up for more than 3 years. Given the overtly tenuous nature of these charges, the prosecution should not reap the reward of lengthy unlawful incarceration before the Michigan Supreme Court can hear and decide this case. Now, in a statement, the district attorney said that Jennifer Crumbley needed to stay locked up due to her actions, not the actions of her then 15-year-old son. Like I said, Jennifer Crumbley was tried by a jury of her peers, according to the statement, and for her own actions and inactions leading to the shooting of the Oxford High School shooting. And she was convicted not for her son's actions, but for hers. A jury of 12 individuals listened to the testimony and reviewed countless pieces of evidence before they unanimously found her guilty as charged, and she was sentenced by the judge accordingly, the DA's office said. This was an egregious set of facts that resulted in a conviction along with 10 to 15 years in prison. Now, the Crumbley parents made history as the first parents to be convicted of a mass shooting committed by their child. Jennifer was sentenced to serve between 10 to 15 years in prison after an Oakland County courtroom had heard evidence arguing the now 46-year-old neglected her son's cries for help over the years leading up to the shooting. She said that James also showed up at the Oxford High School on the same day. Ethan shot people in the hallways to discuss violent images the then 15-year-old drew on worksheets in class with school administrators, but they left and went back to the school shortly afterwards. Earlier this month, Jennifer Crumbley asked the court to overturn her conviction or grant her a new trial. Like I said, ladies and gentlemen, I get it. It's wrong. It's emotional. School shootings, bad, bad, bad. All school shooters, cowards, losers. But their names should be remembered for being that, losers and cowards. But I just got a problem doing it with parents. So basically every child who gets in trouble under the age of 18, under this theory, charge the parents, because obviously you are failing to hear the cries for help of your children. And they're obviously acting out for your attention. And why are you failing them? Let's make parenting criminal, ladies and gentlemen. Next, an Oregon prosecutor, he gets fired. So a harassment investigation into a high-ranking official from the Washington County District Attorney's Office in Oregon found that he had been making explicit comments about the physical appearance of his colleagues, sending colleagues shirtless photos of himself, and discussing his sex life in great detail at work. Yes, that's wrong, ladies and gentlemen. So former Chief Deputy District Attorney Bracken McKee served during District Attorney Kevin Barton's administration. Now, McKee retired this past April after having been on medical leave since September of last year. But of course, what they had to do, it takes forever. A human resource investigation was opened into the DA's behavior within the workplace after he went on leave. Now, the investigation, which included 18 witnesses, looked primarily into 3 allegations. McKee was accused of showing and sending shirtless images of himself to multiple coworkers without their consent, or making sexually charged or body-shaming comments about both male and female colleagues, and of sharing detailed information about dating and sexual encounters with his colleagues. Now, Camille Hughes, a senior human resource staffer for the county, wrote in the investigation that based upon a preponderance of the evidence provided, which is more likely than not, including photos, text messages, and witnesses' statements, all allegations of sexual harassment and offensive conduct against Mr. McKee are substantiated. Now, McKee had been a prosecutor in Washington County for his entire career, working his way up to become one of the county's highest paid employees. Guess what his annual salary was, ladies and gentlemen? $100,000? Nope, higher. $150,000? Nope. $200,000? Nope, higher. $246,536. That's not a bad chunk of change for a public servant, is it not? Anyway, the report on the investigation into McKee was released last week, of course, over the holiday weekend, because we can't embarrass anybody, right? Anyway, so it came out, and McKee issued a statement before the report's release, in which he expressed gratitude for the difference I was able to make in the lives of the crime victims, and then criticizing the county's decision to release the report more than a year after he had left office. He said, as for this investigation, I've had private conversations with people I thought were my friends, and it certainly wasn't my intent to offend anyone. He added the conversation between colleagues occurred in the context of a decade-long friendship in his statement, and obviously is not happy about it. Anyway, once again, ladies and gentlemen, just like your mom always said, right? If you can't say anything nice, don't say anything at all. What does Scott always say? Don't send pictures of yourself to anybody ever, even if they say, yes, please send it, because they always delete that one right before that. I've seen it. Too many cases, ladies and gentlemen. Just don't do it. Act like a gentleman. How about that? Be a gentleman. All right, next on the docket. Appellate judges on Thursday overturned the conviction of an Ohio woman charged with killing her mother back in 2022. Now, Sydney Powell was convicted in September of 2023 of killing her mother, Brenda Powell, and her sentence was to be that of life in prison with parole after 15 years. Now, prosecutors allege that Sydney Powell had not told her mother that she was kicked out of the Mount Union University several months earlier, and her mother was on the phone with school officials when her daughter killed her, hitting her with a frying pan and then stabbing her some nearly 30 times. Well, experts testified for the defense and argued that Sidney Powell, who was 19 at the time, was suffering from a psychotic break when she killed her mother. 3 experts found that she had schizophrenia and she could not discern right from wrong. This is where it gets interesting. An expert for the prosecution agreed that Sidney Powell had a mental health issue, including a borderline personality disorder, but asserted that she was not insane when she committed the crime, and that testimony by the defense expert was not allowed to rebut the testimony of the prosecution witness. The trial court denied Ms. Powell's motion based solely on the conclusion that there had been lots and lots and lots of expert testimony in this matter. Reading straight from the transcript. Lots and lots and lots. That's like an official legal jargon, isn't it? Anyway, the court wrote in their decision, under these circumstances, however, Ms. Powell had an unconditional right to present rebuttal testimony. That's right, ladies and gentlemen. The court cannot deny a defendant a right to present a defense. And just because you've heard lots and lots and lots and lots of evidence, you get to hear a little bit more when the defense wants to do it. Yes, it has to rebut something very specific. You don't get to retry your case all over again. But the fact that the judge didn't allow it, reversible error. So Sidney Powell's lawyers had argued, just for a little background, that she was temporarily insane at her trial for killing her mother back in March of 2020. Powell, then 19, claims to only have flashes of that day, hearing voices, crying, and feeling the need to get away. Prosecutors alleged that Sidney stabbed her mother with a steak knife, hit her repeatedly with a cast iron skillet, and she was charged and found guilty of murder and felonious assault. And when the Akron police arrived at the home of the Powell family back in March of 20, they found Brenda Powell with the life-threatening cuts and stab wounds. They saw Sidney Powell, the daughter, collapsed at the end of the family driveway. Her eyes were rolled back, and she was clawing at the asphalt to the point that her fingernails bled. Now, Brenda Powell was dying on the floor of her bedroom, covered with blood and obviously life-threatening injuries. Like I said, Sidney Powell was bloody and hysterical. The 3 psychologists found that Sidney suffered from schizophrenia and a psychotic break on the date that she killed her mother. And he said that she was having delusions and hearing voices. And so what does that mean when the case is reversed? It goes back to the district attorney. Usually goes back to the judge that tried the case as well, so they can do the walk of shame, so to speak, and have to realize that they've made a mistake. So the prosecution then decides, well, do we say let's go forward and retry it? 2, do we dismiss it? Or 3, do we try to cut a better deal or just cut a deal so that the case can be done and resolved? Now, Sidney's father didn't want her to go to prison. She's got strong family support. Clearly, has got mental health issues. Not really sure sending her to prison for the rest of her life, for at least the next 15 years, is a good call for society. But if that's how you want to spend your money, so be it. In this particular case, it would seem reasonable for the district attorney to say, hey, let's do a plea, credit time served, send you on your way. Next on the docket, food violence. An outraged Chipotle customer violently attacked an employee behind the counter after she claimed they messed up her order. She then allegedly threatened to come back and stab the workers. Take a look at this footage. Captured the woman carrying an empty bowl as she pushed workers aside behind the counter at the restaurant. And this was took place in Washington, D.C. on Saturday. The disgruntled customer briefly shakes them off and then piles food into the bowl. The altercation escalated with an employee, a guy by the name of Roberto Hernandez, tried to snag the mountain of food from the woman's hand, but Hernandez reached to grab the bowl, and then she pulls back and then slaps him in the face, causing food to fly up. Anyway, Hernandez said he was a little shaken after the whole situation, but he didn't feel like he could hit her back because that would be wrong, and he did the right thing because otherwise he'd probably be going to jail as well. Well, as it turned out, the enraged customer was upset that her Uber Eats order was wrong, and her burrito bowl didn't have double meat. She claimed she ordered, so she wanted a refund. However, Hernandez, the employee, said that he and his manager tried telling her they couldn't give her a refund, and she would have to contact Uber if she wanted to get her money back. Hernandez also told the outlet that he checked the receipt for the order, which showed she had not actually ordered. Anyway, as things went on, needless to say, it got ugly. Like I said, Mr. Hernandez tried to stop the attack. He was mad and upset, but he wasn't going to hit a female. Good for him. Now, the violent customer then allegedly went online and threatened the staff after the attack, saying, "I'm going to come back and stab them and take their life." I don't know, ladies and gentlemen. I understand we all get a little hangry every now and then, but you didn't get your double meat order? My God. Next time, get off your lazy butt and go to the store and get it yourself. Go to Chipotle. Don't do the Uber. Besides, all the fees they charge you for that stuff is crazy, isn't it? I do it all the time, but if they mess up my order, they usually make it right. I don't know. Anyway, what can you say? Chipotle did file a police report over the alleged assault, and the woman says that the unidentified woman who says she is the victim in this particular case says that she's going to sue Chipotle. A little more food violence here for you. A pizza delivery driver in Kissimmee, Florida was arrested for allegedly stabbing a pregnant woman more than a dozen times over a $2 tip. Brianna Alvello became upset with a customer over a small tip she received after making a delivery to a motel in Kissimmee, Florida. She later returned to the hotel room with a man, later identified as her boyfriend, and they reportedly forced themselves inside the room. The victim was then stabbed by Aravello multiple times before the male suspect said it was time to leave. Detectives are working to identify the male suspect involved in the incident. Anyway, investigators said that surveillance footage showed Ms. Alavello arriving at the hotel in a red Toyota Camry about 10 p.m. and later returning with a male suspect. They were seen entering and leaving the victim's room within minutes. Now, the managers of the Marco's Pizza confirmed Alavello's delivery to the hotel and that she drives a red Toyota Camry. Now, Aravello had apparently clocked out about an hour before the stabbing incident. Why is that good? She didn't do it on company time. That's right. Stabbing victim can't then sue Marco's Pizza. Anyway, Miss Aravello is being held in the Osceola County Jail without bond. Next on the docket, this day in legal history. On December 27th, 1932, the huge public interest in the trial of Bruno Richard Hauptmann, charged with kidnapping and murder Charles Lindbergh Jr. Now, obviously, this case gained immense national attention, and the trial marked the first time media coverage shaped public perceptions of justice. And on December 27th, 1900, militant prohibitionists Carrie Nation carried out her first public smashing of a bar at the Carrie Hotel in Wichita, Kansas. Now, Nation argued that the destroying of the bar was an acceptable means of battling the liquor trade since the Kansas Constitution prohibited alcohol. And let's not forget, yesterday, December 26th, John Benet Ramsey's case, one of the most infamous unsolved crimes in United States history, occurred on December 26, 1996 in Boulder, Colorado. And finally, our dumb criminal of the day. A man dressed as a Santa escaped from a trooper on Saturday night after an attempted traffic stop in Florida. It all started about 9 p.m. The trooper saw a white motorcycle with blue trim. The man on the motorcycle was wearing a Santa costume and driving in a reckless manner, going over 120 miles an hour and weaving in and out of traffic. At about 9 p.m., the trooper saw the white motorcycle heading westbound and gave chase. Gets up next to him, pulls over, then the guy pulls off. Anyway, they were unable to find the individual on the motorcycle, but they did. The sheriffs did put out a statement saying anyone that recognizes Old St. Nick, please feel free to call the Florida Highway Patrol at star 347 and let us know. They also joked that maybe the sleigh was in the shop for repairs. All right, that's all we have for today, ladies and gentlemen. Hope you had a wonderful holiday, or if you're celebrating a holiday, continue celebrating. Carry on. We'll see you next week, and remember, the Constitution matters.